Good evening. My name is Mark Thompson. I'm the Labor Relations Manager at Barrera Recycling Company, and today I will be giving management's position on the termination of Aaron McNamara, case number 3. First, I will give a brief overview of the facts of the case. Then I will articulate management's position on the case. And finally, I will give management's plan of action should we be successful in achieving our desired outcomes. Ms. McNamara has 20 years of experience with Barrera Recycling. She was recently transferred from our Long Beach facility to our facility in Los Angeles, where she was put under the supervision of Mr. Rafael Gomez. Over a period of 10 months, Mr. Gomez had several conversations with Ms. McNamara regarding work performance and safety issues. According to Mr. Gomez, there were 7 such conversations. According to Ms. McNamara, there were 6. Both of them agree that the final one of these conversations occurred on October 26th when Ms. McNamara was found reading a magazine on company time. 2 days later, on October 28th, Mr. Gomez suspended Ms. McNamara for 3 days and gave her a written notice that failure to comply with any company rule within the next 12-month period would result in her termination. Ms. McNamara did not file any grievance procedure at this time, but took the 3-day suspension. 39 days after Ms. McNamara returned to work, Mr. Gomez observed her working without her required safety gloves. Mr. Gomez felt that discipline was in order, and Ms. McNamara's employment was terminated at that time. It is management's position that when Mr. Gomez discharged Ms. McNamara, he did not violate any portion of the union contract. There are, however, several portions of the union contract that could be relevant to this case, and as such, I will now take the time to go over them and show why it is management's view that they were not violated. The first relevant clause in the current union contract is Article 19, which states that all discipline must be non-discriminatory. In the case of Aaron McNamara, there is no evidence of discrimination. Rather, Mr. Gomez's decision was based solely on the fact that he observed Ms. McNamara in violation of the company's safety rule. Therefore, Article 19 of the union contract was not violated. Article 20, Section 1 of the current union contract states the reasons for which an employee may receive an immediate discharge from Barrera Recycling. Management does not believe that this section of the current union contract is applicable in the case of Ms. McNamara because she had received a prior written warning detailing the consequences of any future failure to comply with Barrera rules. Therefore, the termination should not be considered as immediate. Article 20, Section 2 of the current union contract states that the discharge or suspension of an employee must be based on just cause. It is management's position that the just cause requirement was fulfilled in accordance with the 7-step just cause test laid out by arbitrator Carol Dougherty. At this time, I will now go through the 7 steps of that test in order to demonstrate that the test was fulfilled by Barrera before the termination of Aaron McNamara occurred. Step number 1 of this test, which states that the employee must be given advance notice of the potential consequences of his or her actions, was met through the written notice that Ms. McNamara received upon the time of her 3-day suspension. Step 2, which states that the rule must relate to the business operation and reasonable expectations of employee performance, was met in the relationship between safety rules and the operation of the business. Also, it can be reasonably expected of employees that they will follow plant rules. Tests 3, 4, and 5 deal with due process that the employee must receive, and they state that there must be an investigation before discipline, that the investigation must be fair and objective, and that there must be convincing proof of guilt found through the investigation. While management is aware that this investigation did not happen immediately prior to Ms. McNamara's discharge, it is management's belief that these happened after the final incident on October 26th, before the suspension was given on October 28th, and therefore it became unnecessary to meet them after the final infraction, as warning had already been given of what would happen should there be another infraction. In that case, there was investigation before discipline. The investigation was fair and objective in that management obtained both Mr. Gomez's side of the story and Ms. McNamara's side of the story. And there was convincing proof of guilt, as Ms. McNamara did agree to at least 6 conversations between herself and Mr. Gomez related to her performance and as well as safety issues. The 6th step states that the discipline must be non-discriminatory, which, as already discussed in Article 19 of the union contract, was met. The final step in the 7-step just cause test states that the discipline must be reasonably related to the worker's record as well as the severity of the conduct. And that due to previous performance, Ms. McNamara was given a written notice. It was also related to conduct severity in that Ms. McNamara could have brought injury to herself or to other employees who may have followed her example as someone with seniority in the company. Due to the fulfillment of the 7-step just cause test as laid down by Carol Dougherty, Article 20, Section 2 of the union contract was not violated. Article 21 of the current union contract sets out the procedure for the adjustment of complaints. Section 5, subsection A states that any written warning is subject to the grievance procedure as laid out in the union contract. Management did not violate this subsection, as Ms. McNamara was given the opportunity to file a grievance complaint at the time that she received her written warning, but instead chose not to do so. Should the management of Barrera Recycling be successful in obtaining the outcomes we seek, the termination of Erin McNamara will be upheld. It will also be management's desire to have the precedents laid down in this arbitration hearing applied to future arbitration hearings in which Barrera is involved. Namely, the interpretation of immediate discharge, as well as the fact that steps 3 through 5 of the 7-step just cause test will be considered fulfilled if they are fulfilled at any time related to the discharge or suspension of an employee. In conclusion, it is management's position that no violation of the union contract existed, that Ms. McNamara's termination should stand, and it is management's hope that future arbitration hearings involving Barrera Recycling will use the precedent laid down by this case. Thank you.